Awesome. Welcome, everybody, to Modern Law Divorce Navigator Group's Office Hours Live with Billy Tarasio. I am your host, Billy Tarasio, and this is part of the Modern Divorce Navigator support group where we provide live office hours Q&A with me and with other lawyers and with our legal interns. So, this is a streamed event. You can ask me any questions you'd like, and I will do my best to answer them and spitball with you and give you ideas. Nothing you share is confidential. Nothing that we do on here will create an attorney client relationship. So, I'm not your lawyer, even though we're talking about your case. And this service, which is meant to help you represent yourself or give you ideas, is not a substitute for actual real legal advice. So, with that, Nancy, let's go to you first.
Hi, Billy. How are you today?
Doing great. How are you?
Good. I had sent you over the papers for the on the website.
You posted them. Let's look.
Yeah, for my enforcement.
Okay, let me find them. Here you go. All right.
Sorry.
So, Nancy, you have an enforcement hearing coming up?
Yeah. So we went in. He never served me, so I just went into the court for our first court date because I found out the information. Um, the judge served me the enforcement and then told me that we would be on a video call when next Wednesday for if I can test it or if I admit to it. And then if I can test to it, then I have he has 45 days to prove evidence of all of this stuff.
Okay. So, you posted these 3 pages. Are these pages that you posted in the support group, are they, y- is this what you filed or is this your proposed response? What am I looking at?
This is what he filed to enforce.
Oh, interesting. Okay. All right. So one claim that he's making is that you enrolled him in a baseball program that he didn't agree with because the times and dates didn't work for him. So
So,
that's
like, the date that he has on there isn't even correct.
okay.
Um, it says December. It was actually like we were going through the court process, and he did show up for that day, those days. I don't have proof of that because it was a different phone, and I lost all of that phone, so I lost all that information. But yeah, that was before we got our court order,
Okay.
and yeah, he was there. So that whole thing was just made up.
Okay, so another thing he said here is that you enrolled the kiddo in baseball, and the kiddo told dad that he needed to take him to baseball, and then you reached out about soccer. This is unbelievable that he's even filed this.
That's
And
what I
then,
said.
I mean,
After I started reading it, I was going to ask the judge if I could just contest to it then, but I didn't think that was appropriate because I hadn't finished reading all of it. But even after reading the first one, I was just like, okay, well, that's not true because that's after our court date, and our son plays baseball in September.
okay, so, and then he broke his arm,
And I have a doctor's note for that proving that, yeah, the discharge
and
instructions
then you
proving
took the
that.
kid camping. I don't even know why he's just complaining about you. He literally filed a document just saying like my ex does things I don't like. All right.
I'm glad I'm
So,
not the only one that thinks this.
well, I mean, yeah. So I don't see his entire pleading. So has he filed a petition for contempt?
I don't know what that is. I think that's just enforcement, I believe.
He filed a petition to enforce.
Yeah, to enforce
Okay.
the court or to
Does he
enforce legal decision making.
does it say anywhere in here what he's actually asking for a remedy?
I did not read that. No,
Okay.
I didn't see anything on there about that.
All right. So, I mean, if it were me, I might. First, I would need to look at the entire document, but I might file a motion to dismiss because I don't even know what he's asking for. Like what I've read right here doesn't do what you need to do. So if you file a petition to enforce, what you need to tell the court is on X date, the court ordered Y. On X date, mom did Z. Make mom do Y. You know what I mean? That is the formula.
Okay.
Here's what the court order said.
Okay.
Here's where it was broken. Here's what I want the court to do about it. None of that is included in the paperwork that you put on the sheet. So I might just file a motion to dismiss.
Us to it on Wednesday, or should I just ask her to dismiss? Because we have a virtual call on Wednesday for me to either admit it or contest it.
I don't even know how you're supposed to admit or contest this. It's just garbage, you know. It's just bleh, mom sucks. Bleh. Mom signed him up for baseball.
Well, and I think
Like,
what he wants,
a violation of anything.
I think he's just looking to put me down for him to get legal decision making.
I don't think it makes
Because
him
he
look
had
good.
stated, he's like, don't cry in courtroom again if I get legal decision making.
I mean, I would just probably file something that says I'm unable to respond because the allegations are, I'm not sure what provision he is seeking to enforce.
Okay.
How do you even respond to this?
Well, I kind of was like, okay, if you go to court, how are you going to even prove that any of this? Because the dates are completely wrong. You didn't go to the doctor's office. You don't have the doctor's note. Like, I sent you the doctor's notes for everything. So where are you seeing any of this? And then at the end, it says, I won't go change his name myself. He has to do it, and I won't give him my original birth certificate. It's like, but I wasn't ordered to. So why do I have to do that?
Yeah, so that would be my response. My response, instead of filing a response, I would file a motion to dismiss, stating it is unclear from his petition what exactly he is trying to enforce and what provision he is alleging you broke. And so until he can provide that, you're unable to provide a response.
Okay. All right.
That's a boss move right there, Nancy.
Yeah, I was a little confused when I read it too. I'm like, okay, so what do I have to make text messages of everything to defend myself and make sure I have doctor's notes and this and that? Okay, so just ask to be dismissed. Yeah. Okay.
And if you want to, that's something that you can work with our legal clinic on. They can help you draft the document.
And that's tomorrow, right? At 9:00.
There's office hours with the legal clinic, but if you want them to draft it for you, that you would need to hire the clinic to have them draft that motion to dismiss. But you can also show up with them as part of this group and just ask them, you could write your own and then ask them for their feedback. You can do that as well.
Okay. And how much is that?
It's $100 an hour.
Okay. All right.
Yeah. Thanks, Nancy.
All right. Thank you. Bye.
Deborah, how can I help today?
Hi, Billy.
Hi.
Hi. So I filed my petition for contempt just yesterday. My ex has been keeping my son from me. I don't know if you remember. And he's stating that my son doesn't want to go with me. And I'm concerned, and I don't know if I can do anything about this. He had my 15-year-old sons talk to the police and tell the police that I physically assaulted my mother. That has never happened. Obviously, my mother will attest to that in court, but how is a judge, if this goes further, because I know this man, he's probably going to try to file a petition to terminate all my parenting time. how is a judge going to look at a parent having a 15-year-old talk to the police and essentially lie to the police?
So you have a police report that shows that your 15-year-old reported to the police that you assaulted your mother?
I can barely hear you. I'm gonna have my volume all the way up.
Deborah, you might have to mute yourself while she talks because your audio is really, really loud. I think it's just overpowered.
Is it? Okay. So,
Everybody else hear me okay? No.
Billy, you're
I
fine.
can hear
It's
you.
just- it's Deborah's background noise that's just dropping your audio volume.
Got it. Okay. So Deborah, do you want to mute and I'll answer that?
so let me just clarify one thing. So I filed a police report because his father's not making him come for his parenting time. It was already proven that the father engages in alienation when we went back to court last summer. The TI and, just to refresh your memory, the TI and the court advisor both said that dad is participating in alienation. Well, it's like he's just trying to retry what we just went to court for.
Yeah.
But
Which is why
I,
you definitely need to file to enforce.
so I did that yesterday, but my thing is, I don't like the fact that he's having my son, you know, lie, or maybe they've brainwashed him, but I called the police, filed a report for custodial interference, and dad had the police officer on speaker, was allowing my son to hear everything the cop was saying. And then dad was like, well, he's right here. He can talk to you. And then my son gets on the phone and says that he doesn't feel safe around me because I physically assaulted my mother.
Okay.
Well,
And if I remember correctly, you and your mother did have a fight in front of your 15-year-old, right?
well, it was like a little verbal argument. I kind of like told her off, gave her a piece of my mind, and that was it. And I have proof that there's arguments over at that house.
Okay. So I don't know how you're going to prove that dad has made your son lie. And your son is not ever going to be in court for you to cross-examine him. So I do think it's a good idea for you to kind of defend yourself against those allegations by having your mom testify. But I don't know how you're going to prove that dad made him lie or put these thoughts in his head.
When we went to court the last time, both the TI and the court advisor said that, you know, my son is highly coached. But I'm just tired of him using my son against me. Like, what is that doing to my son mentally?
Right.
You know?
Yeah.
I'm so afraid that my son's like gonna have a breakdown or, God forbid, do something worse, because he's always caught in the middle of a court battle. Like, dad has never stopped. Ever since my son has been 3 months old, he just continuously takes me to court trying to get sole custody. At what point, like this will be round 5, at what point can I say to the judge, look, he's just doing this to try to get back at me?
Yeah.
How
Well,
do-
I mean, I don't disagree with you at all. One problem is that there is recent legislation that is kind of targeting this particular issue, and the legislature has passed a bill that says you can't take a child away from a preferred parent basically as a consequence of alienation. So previously, that's what I would have said, is exactly what you just said. Hey, this is not a good environment. He's caught in the middle. Dad is, you know, has blood on his hands, and the child needs a break from dad and needs to stay with mom. That's what we would have done. I don't
Right.
know how the judge is going to respond to this new legislation, but that's probably still what I would ask for.
Well, we're not, I guarantee you in August, well, I'm afraid that I filed this order to enforce parenting time. Last time I did that, he filed emergency orders. So that's what I'm afraid. He's going to file for emergency orders saying my son doesn't want to be around me. when he's being totally brainwashed by these people over there.
Right.
I mean, how is a judge going to look at just a verbal like argument between two people?
How is a judge going to look at the verbal argument between you and your mom?
Yeah, it was just, she crossed a boundary, went behind my back on something, and she used my social security number to open up a credit card. Okay, and it's not the first time she's done it. So I was pissed. So I told her off for like a minute. And that was it. There was no there was no more arguing, nothing. I just told her, you crossed boundaries, you've done this before.
Well,
I'm so
it's a
tired of
crime,
it.
It's fraud, it's identity theft. Yeah. You being angry about that is completely reasonable.
Yeah, so how is that? I just don't get it. So I don't know how a judge would say that that is detrimental to my son, given the
only thing a judge
situation.
could say is you shouldn't have yelled at your mom in front of your son. That's the only thing a
Right,
judge could possibly say. And then you say, yes, Your Honor, I understand.
right. But that's
But
not,
but what my son is doing is finding any reason he possibly can to not come, to say that he has a reason not to come. And this is not a valid reason. Watching your parent have conflict with other adults is not a reason that you reject your parent, you know?
right.
So I think
And
you
I
just
know it,
lay that out.
right. Okay, so that was my question. Oh, I have one other question. So I tried to call the police after I read that report to do like an addendum, so they could get a statement from my mother. I don't want that hanging out there in a police report that I physically assaulted my mother. The police didn't even call me back. I mean, they have to take a statement from my mother, don't they?
I have had lawyers successfully get cops to change their reports that were wrong because police reports are often wrong, let's be real.
Right,
Um,
right,
but she was pretty successful at badgering the detective manager of the officer to make them change the report. That's your best bet. Like you're gonna have to be really annoying in order to get them to talk to your mom and change the report.
Well, I think if I go talk to a sergeant, maybe.
Yeah, exactly.
Okay, I'll try that. Thank
All right.
you.
Thanks, Deborah.
You're
Allie,
welcome.
how can I help you today?
Okay, I wrote down a list and then I started starring which ones were most important. Then I realized I was starring too much. I'll give you like quick context. My boyfriend's at work today, so I'm also helping him out manage his case. High conflict. They went through a litany. Like he ended up getting awarded full legal decision making, full custody. Mother has supervised visits on Sundays. Mother was exercising her time and then about a year ago said she couldn't afford supervised visits and just stopped exercising her time, but still shows up to their sporting events. And the kids really don't want a relationship. She's estranged, but she's a narcissist, and she was also identified as like borderline personality from Dr. Corsten. So there's a litany of like complexities going on there. She's filed for modification. We're in discovery right now. I also want to call out, I started Modern your navigator, and I think I wish I started it a little earlier to understand the process a little bit better, but it's been good.
Oh, I'm glad.
Okay, so a couple things. So we're in discovery. We filed an order to enforce. She hasn't reimbursed for any medical. She's behind on child support. Her company seems to side with her. Like last May, she said, "Hey, I've got a hearing for child support. It's being changed," and her company just changed the income withholding order before anything was filed. And like they're skipping months on payment. It's hard to get arrearage calculations because the system's been down. So we're like, so order to enforce was medical and child support arrearages and things like that. That got combined into the modification that is pending right now. So I'm curious on a couple things. She has stopped her visitation, and now she's asking for overnight. She's asking a step-up plan over 90 days for 50-50. She's asking for legal decision making again. What is the likelihood, and knowing that the kids really don't want a relationship, she incessantly texts them and calls them. She's done GoFundMe. She talks about their dad negatively. it's a likelihood that a judge will consider it, because one of the provisions was like if she continues to address her mental health, you know, the court will look favorably. Everything that she's done has been pre-decree, with the exception of like an abuse, like women that were abused or whatever. She did a program for a year, but nothing to really treat the underlying issues. And she doesn't believe she has underlying issues. Is it kind of crazy to think that you haven't seen your kids for more than 15 minutes and talked to them for more than 15 minutes in person over the last year, that you're going to get unsupervised visitation?
So when was the last order put in place?
The original order was put in place September of 2023.
Okay.
Nothing's been changed or done since then outside of just a child support modification.
Okay, and she did supervised parenting for until when?
Until May, so from September to May of 2024, and then gave it all up.
And then hasn't done it since. So it's been
And
about
she's
a
just
year.
she's incessantly asked, because it says third-party supervisor or a mutually agreed upon person.
Okay.
She incessantly asks for a mutually agreed upon person. She wants dad to produce somebody, but like he's like, I'm not getting my community to deliver
Sure.
you 4
Yeah.
hours every single weekend. It was just the supervised visitation through like parental dynamics and stuff was a mess. She was changing time, she was changing locations. It was
So she won't propose a supervisor.
She's proposed some that my boyfriend has denied, just because of their involvement and strong opinions towards the divorce and things like that. And he's like, look, he agreed to a few. The kids went to one or two with some of these people, and then they felt uncomfortable. One of them, she had supervised visits, and then she like left the kids at the house, like, and went for fireworks and like just weird stuff with supervised. So he's like, I don't feel comfortable outside of like a professional agency anymore. There's just too much that goes on with a friend, you know.
How old are the kids?
There's 4, one's aged out, one's about to age out. 17, the youngest 3 are 17, 15, and 13.
Got it. Well, I don't think a court's going to force the 17-year-old to do anything, pretty
Yeah.
obviously.
Yeah.
Is it possible that the court will modify it? Yes, that's possible. But it's also possible that if she files to modify, you file a motion to dismiss and say that she hasn't proven any change in circumstance.
We did do that. We had somebody ghost draft a really strong dismissal,
Mhm.
but when I helped him with the RMC statement
Mhm.
and a response, and I did call out, like, so she's claimed, you know, financial poverty, but
Mhm.
she's tripled her income in the last 18 months. She's
Mhm.
making $160,000+ a year, can't afford to see her kids on Sundays for 4 hours. She's, you know, she started at 50, she's at 160.
What does she do?
She's in like investments. She's doing some investment stuff, but she's misled the court multiple times on her ability to earn. She used to make 100K. The courts attributed 50 at the divorce because of her mental health, and she didn't have a job at the time. She found a job. She's been in her job. She's now doing really well in her job. She's making lots of commission checks and things like that. But she still claims this, you know, financial issue that she can't pay for, you know, child support. She really lied in the hearing in May, and we're kind of shocked that the judge, you know, she was on target to make 100K. She made 100K last year, 110K last year. She said, I'm only going to make 50, but she had already made like 8. She was on target to make 80. So like they gave her all reduced, you know, they attributed all reduced income to her over that time. But I forget where the question started.
Well,
the dismissal.
was there a change?
The
Is there a
dismissal-
change in circumstance? And the analysis for a child support change and for a parenting time change are not the same. So
Okay, so in the RMC statement and the response that I did outside of the dismissal, the judge quashed the dismissal, or I'm not sure what the terminology is, and said it was going to move forward because there was changes, I believe, I thought it was because of the child support piece.
is there a pending petition to modify parenting time?
Yes, they petitioned to modify parenting time, legal
Okay.
decision making, and child support.
Okay. And do you have any hearings coming up?
It's set for dismissal while we're in discovery until we complete discovery.
Okay, and you already filed a motion to dismiss. It was denied. So you gotta now deal with the merits of the case, which include all three things: child support, decision making, and parenting time.
Correct.
Okay, and so have you gotten the discovery that you need in order to prove her income?
Yeah, we have her income.
Okay.
I sent over a request for production
Okay.
with everything. They just sent one over to us.
Have
I'm
you
also
asked for child interviews, or how are you going to get the kids'
so the
opinions?
Yeah, Judge McCarthy asked for the CAA to come back in and do
Okay.
it. He also ordered her to pay 100% of it.
Okay.
Nothing, that was about 3 weeks ago, and nothing, we haven't heard from, it's Carrie Rusk. We haven't heard from Carrie Rusk at all.
Okay.
I'm not sure if it's something like, we really would love not to have a hearing and just get child support modified. So there's a part of us that's like, do we press Carrie Rusk or we let her press Carrie Rusk because she's the one filing? Or I'm not sure how that would look either.
Well, I think because it's all combined and you want child support changed,
Sure.
you're not gonna get away with kind of like making some issues disappear, but some issues go forward.
Okay, that's helpful.
Yeah.
When we think about like, because our position, a lot of it is finance and her inability to prioritize the kids because of finances. She'll say she's going to give them money for prom dresses and then not do it. She hasn't, done medical. She's claimed them on taxes. She didn't reimburse for, medical, and her child support's, under. So we're working on like, things like that. But how does the court look at like extra? The kids are all teenagers. They're expensive as teenagers, and child support doesn't really account for teenage, kids that are actively involved. Like his two oldest are going to school on almost full ride scholarships for women's wrestling. They're in a lot of sports. He bought a car. He pays for car insurance. He pays for a cell phone. None of that's calculated or considered. And Judge McCarthy wrote the final decree. So like, there's a lot of things like how extracurriculars are to be split or anything that's all missing. So how does the judge look at things like that as we come up to the hearing?
There's no law that addresses your question, which means it's completely discretionary.
Okay. The last thing, I guess the last question I'll ask is, which one do I want? I guess there's two. I'll make it short. Child support. So in the initial decree, he was awarded $13,000 in back child support and then about $15,000 in specialist and attorney fees. We are actively going through the writ of garnishment process for the specialist. I wonder. I asked it in the group the other day, and I got a variety of answers. The child support judgment's like $13,000, and it says to be paid in arrearages $200 a month.
Okay.
Can we do a writ of garnishment against the back child support because there's a provision that says $200 a month?
No, you've already got your garnishment. You've already got your income withholding order.
Okay. So I would have to ask the judge to modify that and put it in a lump sum. Okay. And the last question I have is contempt. So I have the order to enforce, but she's claimed the children on taxes. She's also seeking time with the kids and asking to see them. And I'm always allowed to see you whenever you guys ask, which is not the case. Order says you are not to, ask for additional parenting time outside of your supervised visits. Can I file a contempt motion in tandem with the modification, or is that seen as like too much and overbearing?
I would be more likely to file a petition for contempt regarding claiming the children when you weren't supposed to, because there's a remedy. You can ask that she be ordered to amend or ordered to compensate you for that.
Okay.
I would not personally usually recommend filing for contempt based on mom asking for parenting time.
Okay. Lying on an AFI, how do you feel about that? She like completely lied on.
It's not contempt.
Okay.
It's not contempt. It's perjury.
Do you just use that in the hearing to say that she lies about it? Like,
You use it on cross-examination, or you use it to undermine her credibility.
okay.
All right, Ellie, if we have
Thank
more
you.
time, I'll come back to you.
Sounds
Thanks.
good. All good.
Ashley, how can I help you today?
Hi, Billy. How you doing today?
Doing great. How are you?
I'm great. I appreciate you. Thank you.
No
So
problem.
I was at your pro bono in Mesa a couple weeks ago, a couple months ago. I don't know. It's been a while. And I'm just going to give you a little bit of a rundown in case you don't remember me. So my narcissistic, abusive ex had custody of my kids for 10 years through the court systems. And he is currently going to jail for child abuse, or he's whatever. He's in trouble for child abuse right now in another state. So I have temporary custody of the kids, and I missed some paperwork back in November. So the temporary custody is like she gave me everything. It was Judge Wu, and he's supposed to have supervised visitation. But I missed some paperwork in November that was stating that it was going to be put on a dismissal calendar in February. So when I realized that, because I check the court website all the time. So when I realized that, I went to the court and filed a blank motion with the judge explaining to her what happened. And then I filed if she could please make the temporary order permanent. She told me, well, whatever. The court paperwork said that there needed to be some other things put in place. And when I came and saw you last time, I don't have my exact notes right now, but you had said that I needed to do a financial affidavit, a discovery, and a disclosure before I could file. I can't remember what now because it's just by the chance of the universe that I'm here right now on this live today. So I don't have my paperwork, but my first question is on the discovery and the disclosure. I understand what I'm needing to get. I need to get my husband's work information, our bank statements, or like W-2 information, tax stuff, all of that. My question is, how exactly does this work? Because I'm going to come up with all of this information like this, and I'm going to just mail it to him like this is my evidence. And then I'm going to request him to send me stuff because I know for a fact he's not going to be like, this is how much I make. Like, here's all my information. Like, there's going to be issues. So that's my first question is like, how does the discovery and disclosure work? Like, what does that mean? And how does the court make sure that I'm actually giving it to him? Like, what's the proof that I gave it to them?
Okay, so your issues are child support, parenting time, and decision making, right?
Yes.
You have a temporary order. He's facing criminal charges in another state. The parenting
Yes.
time and decision making stuff you kind of already have, right?
Yes. Yep.
So the only real issue here is child support. What does the
We
court...
do have. Sorry.
Go ahead.
So we do have. When I went through all of that, the judge, I didn't want to request anything, but she made me do it, and so they ordered him to pay child support, which.
Okay.
It comes out directly from his check. So he did go to the court at one point and try to ask them to stop it because I can't afford that. But it's already in there.
Okay. So the judge already made findings about his income.
Right. Okay.
So,
Okay.
And you gave the judge your income information when you went to court previously.
Mm-hmm.
Okay. So you could just file a motion to set trial.
I don't need to do a discovery and a disclosure because that's been my holdup so far.
I mean, it
Like, do I
doesn't
need to come up with
sound-
the whole evidence? Like in my head, that meant like I need to come up with all the evidence that I'm going to give the judge to and send it
that's
to him
true.
now.
That's true.
That is true.
Any
Okay.
evidence that you want to use at your final trial, you have to have disclosed to him. Okay.
Okay. And I can
So-
just can I email him? Can I mail it to him? Do I have to file something?
You don't. You don't have to file
Okay.
anything. So, when we send these documents, we do disclosure statements. They don't get filed, but they are basically like a list of items we gave you and when. It's like our receipt
Okay.
to say,
Yes.
we gave you this on this date. But basically, anything you want to use in court, you have to send to him in advance. Once you do that,
Okay.
you can file a motion to set trial, and you can move
Yes.
forward because you already kind of have the order you want.
Right.
based
Everything's in place
on-
already. I just wanted to make it permanent.
Right, based on evidence that she's already seen.
Okay. Now, with that being said, when we went the last time and I had to, present my case to her and I had all of that evidence, I had like 30 things that I had to put into like a court system, like the computer or something. is that stuff still in there? Would that stuff still be in there? And then also, okay, would that stuff still be in there? Because my brain's going a mile a minute now.
I see that. Okay, so first, that means you disclosed those 30 things already to your ex, okay?
I already sent them,
Yeah, you don't have to do that
so I don't
again.
have to.
You don't have to do that again.
Okay.
Now,
There's only a couple new pieces that I need to send.
you just email those over.
Okay.
Now, when you get your new trial date, you will be
Yes.
asked to upload any exhibits
Yes.
you want to
Okay.
use. at
That's
that
where it
hearing,
is.
which means that you will re-upload anything you want to use again.
Okay. So I'll re-upload. Okay. So I literally feel like you answered all my questions for that. So the reason I'm here today, Billy, is because the universe brought me by a young lady and she is in desperate need of some advice. And she's really, really, really scared. And so she sent you guys an email this morning because I directed her to you directly because I knew that you guys helped me and I felt safe with you guys. So she's really scared. I don't want to cry. Okay. Sorry. So I'm going to give you a little bit of a rundown and see if maybe you can give us an answer just to give her some help. She's sitting right here next to me. Okay, so Rhiannon, right? Rhiannon. So Rhiannon, she has a lady, her mother-in-law, who has custody of her son, but we couldn't find any paperwork through the family court. And at one point there was a CPS case, and she does have a piece of paper that said that there was permanent guardianship given to the grandma. But some of the paperwork looks really strange. Like some of it looks real like a template from like they printed something off. It looks really weird. Mom's been sober for a year, and they had a verbal agreement with grandma that after 6 months, son could come back home with mom. And now it's 6 months is here, and grandma is telling like they want her to go to court today because grandma wants her to go get joint custody. And so she's so confused right now because it doesn't make sense if they already have permanent guardianship. Some of the paperwork says permanent guardianship because we couldn't get a hold of mom and dad at some point, but we're giving them an opportunity to reunify.
What she wants, the grandma wants mom to go to court today. Where?
Yes.
Family court or probate
Family court? Or what? Probate court?
Yeah.
So
So
she didn't say. She said she just talked to one of her family members to go down to the courthouse
oh,
to get papers for joint custody.
okay, okay.
But I
So-
want full custody.
Okay.
You wanna
I want full custody. I'm trying to get full custody back.
Yeah. So there's a permanent guardianship in place that can be through two areas. It's either through the juvenile court or it's through the probate court. It's probably through the juvenile court. So what we
Okay.
need to do, you don't file anything in family court. You have to end the permanent guardianship through juvenile court first.
Okay.
And then you automatically have full and sole custody.
So CPS wouldn't be brought back into it?
They
No.
told her this morning that if she didn't
CPS
go
is
to
closed.
the court, that CPS would be brought back into her life because it hasn't been a year since they've been out of her life.
I mean, so this is a juvenile court case, and it's definitely something that we can help you with, but we would have to look at the whole case to understand what's going on.
I don't even fully know
Right.
what from the get-go. I was in a really bad part of my time of my life, and I don't even know how there's a lot of weird stuff that played into it that I don't understand, or even if it's real, because I haven't been able to find anything. And then when I ask her if I can even see the paperwork, she freaks out and doesn't even let me see it.
Maybe you go to the juvenile court and you request a complete file of your case.
Okay. All right.
That'll give you a much better idea of what it is that you need to do. And then
We were
start
looking up on
finding
family
court.
court, but I didn't think about juvenile until
Yeah.
later.
Thank you, Ashley. I'm going to head over to Maria now. How can I help you, Maria?
Oh my goodness, thank you guys so much. First and foremost, Billy, you are my hero for doing this. You have no idea. I honestly, I'm in tears right now because I'm so grateful that I have this opportunity with you. So thank you, first and foremost. Secondly, I'll try to be as condensed as possible because I'm in a hodgepodge. I mean, a hodgepodge of a mess. And I've tried every outlet out there to get help. This case has been going on since 2017. We are divorced now, so this is all post-divorce.
Okay.
Basically, just the rundown here, and I've sent a couple emails to your people and whatnot. Basically, post-divorce, through the divorce period, my ex-husband has connections through the court, and he has stated this, he has said this, he'll never beat me in court. My best friend is friends with all the judges, and so far it's been very true. And I got a really shitty, excuse my language, shitty raw end of the deal. Through the entire marriage, which I was married almost 10 years, I made more money than him. I contributed to the retirement funds. I was a working mom. At the end of the marriage, I was not working. I was a stay-at-home mom. I got no alimony. I have had probably up to a dozen eviction notices that I have got me and my children through by selling my Apple products, my jewelry, so on and so forth. And I'm here now at a spot where we go back to court. I went for modification because he didn't even pay child support for about a year after the divorce, which he's supposed to. I tried to bring that up. That just got overlooked. He didn't provide insurance information, which he was supposed to for about a year. Was working, never paid child support for about a year. He's now working as a manager at Fidelity, makes over $100,000 a year, lied in court, said that he's paying $1,000 to this child that we found out after he just barely had after the kid's a year old. So he has to pay hardly nothing. So he pays $400 a month, something like that. It does, I mean, I can't even poop on that. I can't even feed my kids. I have an 11 and 13-year-old, straight A students. They're wonderful, and they're being affected by this greatly. They go to his house, they eat steak, sushi, and they come here, and it's not the same, and it's just hard. So first things first, I've asked for discovery. I don't know what I'm doing. It's such a hodgepodge. I've been threatened by him. I've had domestic violence with him. I had a restraining order previously. None of that was brought up in court through the divorce because I had a shitty, just crappy, like modest means lawyer. She didn't care. I don't know if she knew his lawyer, but I got screwed. I got no retirement. I didn't get half the retirement that I put in, no alimony, nothing. And so it's just been a struggle. It's ruined my life. Honestly, I'm like at the point where I'm depressed. I'm just hanging by a string. You know, I'm hanging by a string. Financially, I'm in a bad situation with my credit. I can't get a house.
Right.
So
Can I ask you some questions? Is that okay?
yes, ma'am.
Okay.
Yes, absolutely.
When did you get divorced?
2019
Okay.
is when it was final.
And your retirement was not divided.
It was his retirement per se. When I first got married, I had some stocks and I had Walmart stuff and whatnot, but we all just combined everything. So the entire time we were married, I'm putting into his retirement and I paid
here's what
for.
okay, Maria, I'm going to ask very specific questions, okay? Because I know there's a time.
Yes.
But was
Yes.
the retirement account, were they divided in the divorce decree? Were they awarded?
No,
They were not mentioned.
nope.
Excellent.
I don't believe so. In the
Maria,
divorce decree that he made, no, I don't believe so.
Hold with me here. I want to help you, okay?
Sorry, you were cutting out. Sorry.
Okay, no problem. If they were not mentioned, they can still be divided. Okay? We can go back.
Even if it was in his name?
Yes. So undivided, unmentioned community property, which is what you've described to me, is still divisible, even though it wasn't mentioned. So that's good news.
What if it was mentioned?
In the decree, if it was given to him, if it was given to him in the decree, then I can't do anything about it. Your appeal
Okay,
window
okay.
is gone. You know, we've all of those remedies that we could have done to fix that error would be gone. But if it's not mentioned,
Okay.
if there is community property unmentioned, we can still go back and get it. All right. Now,
Okay.
what is the custody plan right now?
Oh, it's crap. It is 5225
Okay.
at the moment. And he has final decision making, which is shit also. Excuse my language.
Okay. And so one of the hardest things, I think, one of the things you're trying to fix is that the children have a very different lifestyle at dad's than they do at your house.
Yes, correct.
Okay.
Correct.
And-
And he is purposely manipulating that, yes.
And are you currently working?
I am not, but I do have a job lined up. I had 2 shoulder surgeries back to back and a hernia surgery, so I've been through some physical, ailments and whatnot. So I'm on disability right now, SSDI. I get
Okay.
$3,000 a month.
Okay.
So that's what I'm living off of, and it's extremely difficult. It's very, very tight.
Okay. So then, do you have a current petition to modify child support?
That's what I'm waiting for. I'm scared to do it because everything I put in, I either don't do something right or I don't know if he's in with the judge and I'm getting an unfair deal because everything just gets turned away or dismissed.
Most likely, you're doing it wrong.
I
The
hope so.
judges follow the law. They have to. They have to. If they don't, they're subject to appeal, they're subject to being overturned. So probably we just didn't get the process correct. And through the support group, we will help you get the process correct, okay?
Okay, okay.
So what we have to do
Um,
is really separate your different issues. So child support is one
Okay.
issue. So we have to file a petition to modify child support. Is
Okay.
there unpaid child support that he owes you?
Yes, yes, the court didn't, and I tried to mention that, they didn't even look at it, but yes, he was working for a period of time, and then he was also paying the wrong amount for quite some time, $6 a month. And I'm struggling to put food on the table, yeah.
Yeah. So part of your petition to modify should also be a petition to enforce unpaid child support. Then you'll get a judgment for the arrears that he owes you. Now, you can only get money for what the court has ordered him to pay. There is no retroactive modification of child support, okay?
Now,
Not
let me ask you this, because that's the issue, because he did not pay child support for a period of time when he was working, but there was no, I think there was I don't even know if there was an order in place.
Okay, so
you
if
know,
there was
so
not an order in place, the ship has sailed, it's done.
I think there was, but it was for $6 or something, and I think he paid it through that time, but he was making a lot more. That's what was going on.
Unfortunately, Maria, we cannot go back and fix that mistake from 2019 because the appeal window
Wow.
is gone. So we have to deal with what can I do today? You cannot go back
Okay.
and redo your divorce.
So no alimony, no nothing. I can't get any. I mean, it's ruined my credit. Nothing.
It's
Okay.
not possible.
All right.
So if there are errors like that on divorce decrees, we have to make a move within 30 days for an appeal and within 6 months at the very most for any of our other potential remedies. So when people come to me, Maria, like you, and it does happen where divorces go horribly, horribly wrong, and then they want to go back and fix it years later, we cannot.
Got it. Okay.
But
Next
you may-
question.
You may be able to ask for an upward deviation of child support, and that is something that we may want to look at.
Okay. Okay. Yeah, because I've basically just my credit's ruined. I've gone broke. I mean, I have no money in the bank, nothing, because of just trying to support my children literally over the years. Literally, I'm scared to go to court because I'm scared of him, number one, and he's threatened my life. He threatens me all the time. He got final say, which there was no rhyme or reason in my last hearing why he even got it. So I was going to try to dismiss that. I put in an emergency order because my daughter is threatened to kill herself after she found out about the baby. That got dismissed. So I guess my next question, let me stay focused here, is that discovery and disclosure. He lied on his affidavit. He's lied about his money for I don't know how long. He took all the money. I never got anything in the freaking divorce. And he's still lying about it, saying he pays $1,000 to a baby in Texas, which I know is a bold-faced lie. How do I find out, or how do I get that information where I can show the judge that he's not paying that? That's where, it's a lie. He's not provided insurance. I've provided insurance for my children, and that's why they make his child support so low, because he's supposed to provide insurance, and they don't even use it. I had to go get them on access,
Okay, so after you file your petition to modify support, that is when
So
you're
that's first.
allowed. That is when you're allowed to do discovery. Okay, so if there's no open case, you can't do discovery.
Okay.
Now, how do you make him prove that how do you prove that he isn't paying for this kiddo in Texas? you ask him to prove that he's paying for the kiddo in Texas. You ask him through discovery to provide to you receipts and evidence of this baby, of these payments.
When you say through discovery, what does that mean exactly?
Yes, so there's a whole class, because I do have 2 more people in the group that I haven't talked to, and I want to talk to both of them.
Sure,
So
absolutely.
there is a class in the Navigator on discovery and
Perfect.
disclosure. There are
I will watch that.
specific discovery tools, and also come back next week, okay?
Yes, I do have one last question, if I could, please.
Maria, I'll come back to you if I can, okay?
No problem. Go
Thank
right
you.
ahead. Thank you so much.
All right, A. Nieto, how can I help?
Really, I
There.
just had a quick question. So, I told you last week I did retain an attorney, and so we're kind of going through the documentation process to file the emergency sole decision-making order. And in that, I think there's going to be a couple different orders. So we'll be signing or doing the emergency sole decision, and then we'll be doing contempt for not paying like out-of-pocket medical and all that stuff, and then um, modified child support. My question is, in providing documentation so that I'm not paying my attorney to read a bunch of stuff that isn't necessary, what kind of stuff is going to be like good documentation as far as like OFW messages and things like that? Like even like trying to show the pattern, right? Of like he says he's going to do this, that, and whatever, and then he doesn't do it. Um, so do I show different scenarios? Like we signed up for swim. I have, like we agreed, we, set up the schedule. I registered them. He paid for half, and then he doesn't take them, and then he's like, I never agreed to this.
Okay,
And it's like,
it's a great
is that stuff
question.
matter or leave it
Such a
out?
great question. How do you know what you're supposed to tell the judge and show the judge, right?
Yeah.
So you start with the statute and the legal issue. So you just told me that you're doing all the legal issues all at once, right?
Yeah. Yeah.
Okay, you're going to have to segment those. So on the issue of X, this is what I have to show. These are the examples that support it. So before you even look to the examples, you look to the legal issue and you determine what do I have to prove so that the judge gives me what I want on this legal issue, because they have to follow the law. So the law will dictate what it is that you use, okay?
Okay.
So if you're looking to prove contempt and the order says that he has to, respond within a certain period of time, then you would use the example of when he didn't respond within the specific period of time as an example of contempt.
Okay.
Does that make sense?
Yeah, yeah, yeah. Okay. So like one of the big things is like we have our oldest in therapy, like he's seeing a counselor, and dad initially consented, and then since then he's been like, I don't consent, I don't consent.
Yeah.
I'm not paying for that. But like every time he goes and then he doesn't pay his half, that's contempt, right?
If there's an order that says he owes half, then yes, that's contempt.
Yeah, for out-of-pocket medical. Yeah.
So you would want to use these in 2 different ways. Under your contempt section, you would use that information. And then under the legal decision-making analysis, you would use his wishy-washy and withholding therapy and withholding consent as a reason why you need final say.
Okay. Because even though I have final decision making, like him like saying I consent, I don't consent, I consent, I don't consent, or like withholding the consent, is that considered contempt because he's not like acknowledging my final legal decision making?
I mean, no. It's only contempt if there is a specific order that is knowingly and intentionally violated. So he's not committing contempt. He's just giving you all the reasons why you need final say, which you already have. So what you could do is you could ask the court to order him not to engage directly with medical personnel. You could say you could ask the court to say all discussions have to take place between mom and dad, and only mom is allowed to communicate with the doctors if that is the proper remedy for his behavior.
Okay. That's if they don't give me sole decision making?
Sole decision making and final aren't that different. I mean, even if you get, I do think soul in your case is very appropriate and would really help, because that would make it crystal clear to the doctors. So maybe that's what
Right.
you ask for. Maybe you say the remedy is I need soul, because even with final say, he is completely undermining my ability to get my child the medical care they need. So I
Yeah,
like that
yeah.
argument.
Okay. Okay, cool. I just wanted to make sure I wasn't sending a bunch of random stuff and paying them to read things that weren't going to help.
Absolutely. No problem. All
Okay.
right,
Thanks,
Nicole, how
Billy.
can I help? You're welcome. Bye.
Hi, Billy.
Hi, Nicole.
I, much to my surprise, I got some disclosures this morning
All
in the
right.
mail. And they are laughable at best. And there is no parenting plan, no child support worksheet. Literally, the only things that were included were a copy of the previous protection order that was quashed, and copies of his current incarceration charges, copies of the house purchase, just random stuff, all forged by the power of attorney that has already been told that the judge is not going to acknowledge. I tried to send a follow-up email to his email to confirm that it was him that sent it, in which she said, no, I signed all that stuff. What do I mean, he didn't even comply with any of the required disclosures. I know nothing about his income. These were less than helpful. I don't know. I'm at a loss.
Okay, so he's in prison, right?
Correct.
Okay, so his income is zero, right?
Except for this affidavit that the AFI that they filled out lists her income.
Okay.
Yeah, like what is this something that I need to be concerned about, or is this no?
No.
Do I worry about like a motion to preclude or anything like
Why? Why?
that? Okay.
How does this hurt you or make it any less likely that the judge is going to give you what you want?
Okay. This is more of just to add stress to the pile. Okay.
Yeah, I can understand. Yeah, but like, no, this is of no consequence to you. You want a sole custody order, right? And no parenting time to dad, right? That's what you
You're
want?
in prison. What do you think you're gonna have? Also, yeah, you have documented history of neglect and abuse. You've
And you
signed
don't-
away the rights to your kids. So
And you don't want anything else, right? That's what you want?
that's my goal.
You don't want child support, right?
I don't want anything. I have tried a global settlement offer. Leave me alone, and you can have it all. Keep
So,
what you want.
Nicole, let them be silly. Let them waste
Okay.
their time. Let them disclose what they want to disclose. You have everything you need for the judge to give you what you want.
Do I bring this up in my attempted joint pretrial statement?
That they're disclosing irrelevant things? No.
No, that they disclosed stuff, but it was of no merit.
No.
Okay.
It's not even related to any of the legal issues. So, what your pretrial statement, you guys, it's very difficult, but you have to be very, very disciplined in
Okay.
family court, because there's so much stuff that goes on in family court that you like want to tell the judge, but it has nothing to do with what you're actually there to do, which is just
Right.
judge, you have to make a decision on legal decision making, on parenting time, and on child support. As long as you make sure that you get the information in front of the judge that is crystal clear and related to those issues, and you stick to what is relevant and in front of the judge, you're going to be just fine, and ignore the rest.
Okay. I can do this. I can do the hard
It's
thing.
very
Okay.
hard.
It is. It is. But I can do it.
You can do it. All right.
Thank
Thank
you.
you all for coming today, and I will see you next week.
Thanks, Billy.
Bye.
Bye.